plays in the Larry Whaley case in anticipation of today, because today's going to be a huge day in this case, because the defense is going to have to argue away what Mr. Whaley did, which is firing a weapon at a door and when somebody was trying to come in. That seems like second-degree murder. So it's going to be very interesting how the defense plays this out. You're watching the testimony of Mason City Police investigator Terrence Prohaska, who interviewed Whaley about the events of that day and who he said he felt a threat under his life. But it's going to be very interesting to hear how the defense moves forward. And here to help me talk a little bit about this, I'm very happy we have a great guest with us, criminal defense attorney Carlos Tanner. Mr. Tanner, thanks so much for being on the program.
Glad to be here, Jesse. Thanks so much.
So let's talk a little bit about what's going on in this case. The idea that this is a second-degree murder, it seems pretty straightforward that you fire a weapon into a door, your apartment door, when somebody's coming in. It seems like you wanted to kill somebody, wanted to cause injury in some way. It's a dangerous activity. It resulted in a death. How is the defense going to say that this was an unintentional accident?
Well, it seems that the defense is trying to attack this case or have this battle on two fronts. On the one hand, they're arguing that it's an accident to basically attack the state's case and say that the state can't meet its element in terms of proving malice aforethought and negating the elements required to establish this as a murder as opposed to maybe a manslaughter. It looks like that's what they're trying to do. But on the other hand, what they're trying to do is argue an affirmative defense, the affirmative defense of self-defense. And it seems like they're mutually exclusive or counterintuitive. But one of the things is I think they're narrowly arguing the accident point to say that it was not an accident that he fired the trigger or fired the gun, but that it was an accident that he killed or shot this particular person. On the other hand, he's trying to put forth enough evidence to get a jury instruction that would allow the jury to at least consider self-defense, to say basically as an affirmative defense that even if the state meets all their elements, I still should be found not guilty or maybe found guilty of perhaps a lesser included offense.
But has there been a case that you've seen where somebody maybe wanted to kill another individual and in taking some act to do that, it resulted in the death of somebody else and they had no intention to kill this person, they never wanted to harm this person, it might have been an issue of self-defense. Is there any way that he could be found not guilty, or as you said, is it something that he might be found guilty of a lesser included offense?
I think in this case, a win for the defense would probably be a lesser included offense. It's at the end of the day, a 19-year-old young lady was killed here, and somebody's going to have to pay for it. And it's without dispute that Mr. Whaley pulled the trigger, that he fired through the door. And so the notion that he got free is a pretty far idea. However, there is a chance that a jury could consider, especially the details of the to conclude that maybe there was a threat, even though this is outside the normal realm of self-defense, because Mr. Whaley, at the time he fired the gun, had no idea who was behind the door. But you can see that the defense has been trying to plant seeds the whole way through the trial, particularly with the testimony of Ms. Ewing, who talked about both of them kind of having situations leading up to the shooting that had fear for their lives.
Let's talk a little bit about that, these two men that were apparent threats to Mr. Whaley. So we're talking about Corey Mays, who was his former roommate and apparent danger, and then also former who any way that could be reasonable interpretation. I mean, let's not forget, Mr. Whaley was a Marine, okay? So his level of understanding of what threats were, if what he actually believed was a threat, that might be a different than what any other person thinks is a threat. So he understands the nature of a threat. To really believe that these two men could harm him, could cause harm to him or Miss Ewing, maybe that's a flavor of he might have been reasonable to think that there was something going on.
You bring up a very nuanced point. As you know, the question is not going to be some unreasonable standard. What the jury will have to consider is whether, considering all the facts that were going on with Mr. Whaley and Miss Ewing, whether their belief of imminent danger or harm was reasonable under a reasonable person standard. And there was evidence, or there was a suggestion that maybe there were drugs involved. I know Miss Ewing admitted during her testimony that she was under the influence either at that time or around the time of the incident. But as you know, self-consumption of narcotics or alcohol is not going to be enough to get a judge to put it before a jury that made their belief to be more reasonable than it would outside of that sort of circumstance.
Now, I have to ask you the million-dollar question here. We're seeing in self-defense cases, we cover a lot of them here on the Law and Crime Network, where the defendants take the stand. The defense is beginning their case today. Don't you just feel that Mr. Whaley would love to tell his story and take the stand? Do you think he's going to do it here?
Well, from what I've read in the case with Mr. Whaley having sent multiple letters to the judge, I'm guessing that if not now, at certain points during the preparation of the defense, there was a bit of a client control problem, which is most defense lawyers' worst nightmares, other than a guilty verdict. So my prediction or my assumption here is that Mr. Whaley wants to take the stand. He wants to tell his story. Although, that comes with a lot of peril. You have to travel that ground very carefully because, one, it opens him up to cross-examination, and there's a serious question as to whether he would be able to withstand a vigorous cross-examination. And I've looked at both sets of lawyers for the prosecution and the defense, and all of them seem to be very skilled practitioners. And I don't know if Mr. hold up under vigorous cross-examination. But again, I think that's part of why the defense has been trying to get enough facts in for their self-defense argument through other witnesses.
So our viewers love this stuff. They love when the defendant takes the stand. It really gets meaty testimony. What would be the things to look out for, specifically under cross-examination, where it would be an uh-oh moment for the defense that they would catch him saying? What would be the worst things that Whaley would say under cross-examination that would really be incriminating?
Well, it's not going to be big gaping holes. As you know from having practiced and been so close to the trial arena, at the end of the day, the devil's in the details. And what's going to happen, usually your best points of cross-examination is when somebody has a story, and I'm not saying Mr. Whaley's wouldn't be true, but, in these circumstances, there are always going to be details that you might not have thought of or that you might have left out, such that some of the answers that Mr. Whaley might give under cross-examination wouldn't comport with what we as viewers, or certainly not the jury, knows to be real life.
Now I have to ask, just because you're on the program, would you put him on? Obviously, you don't have the. We're not as intimate.
That decision, and I don't want to second guess his decision nor the decision of his lawyers. Like I said, I think they've done a fine job thus far, but it will give me a lot to think about, particularly where taking the stand opens certain evidence up that otherwise wouldn't even come into the trial. Just by him taking the stand, those sorts of matters get to be put before a jury, where if he doesn't take the stand, he still has those protections.
It's a great diplomatic, lawyerly answer. I love it. It's fantastic. It's exactly what we wanted. Stand by, Mr. Tanner. We have some more analysis to talk about. I really want to talk about the investigator Terrence Prohaska. Really good testimony here where he interviewed Mr. Whaley, gets into the details about what was happening. I'd love your thoughts. So let's play a clip. It's the next one here where we're going to listen to investigator Prohaska really get into what happened that day. Remember, he interviewed Mr. Whaley, and when we get back, we'll do some more analysis.
Okay.
Did the defendant say where he went after he went to where Jenny was staying?
Yeah, after he left Jenny's, he went to Walmart again.
Did the defendant say why he went back to Walmart?
Yep. Yes, sir. He described he went back to Walmart to purchase a flat screen TV for his apartment, and he also purchased several food items.
Did the defendant, after leaving Walmart the second time, say where he went?
Yes.
Where did he tell you he went?
He said he then traveled back to his apartment on 17th Street.
When the defendant got back to his apartment after his second trip to Walmart, did the defendant tell you if anybody was in his apartment?
Yes, he said when he got back to his apartment that Deb Ewing was in his apartment, and that Deb had told him that Samantha and Caleb got into a small argument and they left, and then he said that Deb had told him that Samantha was coming back.
So the defendant during this interview did tell you that
Yes, sir.
Deb said that Sammy was coming back?
Yes, sir.
Did the defendant talk about placing any items by a door?
Yes, sir.
What did he say?
The defendant said after he got into his apartment and locked the door, he placed kitchen knives in the door jamb to secure it shut. Even if you had a key, it would prevent the door from opening.
I'm going to show you a couple of photographs. May I approach, Your Honor?
Yes.
First, I'm going to start with, pull up State Exhibit 40. Investigator Prohaska, it's been described by investigators. There were a couple of knives found, and the diagram shows where in Mr. Whaley's apartment on the floor. Do you see that?
Yes, sir.
Okay. Then I want to put up State's Exhibit number 32. Do you recognize this photograph?
Yes, that's the door jamb where the knives were stuck in.
Okay. And when you say it's the door jamb, first I'm going to, if I may have permission from the court for Mr. Dalen to be able to move the door so we can describe how this is done.
That'd be fine. And then, Mr. Dalen, when you're done, if you could maybe set the door down so it's not blocking the court's view of the screen, that'd be appreciated.
And Your Honor, if I may have permission for Investigator Prohaska to come down, I think it might be easier if he shows the jury.
That's fine.
Investigator Prohaska, when the defendant was describing putting knives in the door, can you explain what we're talking about?
Bear with me, my hands, the knife. Larry described putting the knives in the door like this. That would prevent the door from opening up right corner. There's two knives right about this area.
Go ahead, I'm sorry.
It's similar to like somebody, if you've been in a hotel where you have that. Basically the same.
And I'll have Mr. Dalen move the door before you sit down. Then I'll have you refer to State's Exhibit 32. Mr. Dalen, I think they went on the side if you could.
On its
Investigator, I'm sorry, just a second. Oh, wait, Mr. Dalen finishes here.
It's okay. I appreciate that, Mr. Dalen. I didn't realize you'd be doing moving duty today, but
Investigator Prohaska, looking at State's Exhibit 32, were you able to see any impressions in the door jamb that were consistent with the blades of knives? Would you show the jury what you're looking at?
Right here. You can see a dark slit. It's hard to see, but there's a couple of impressions in the door here, right where the two pieces of wood meet together.
And that, you said, would prevent a person from opening the door from the outside. Thank you. You may have a seat.
Hey everyone, welcome back to the Law and Crime Network. I'm your host, Jesse Weber. You're watching the testimony of police investigator Prohaska in the Larry Whaley case out of Iowa. Remember, Larry Whaley is charged with second-degree murder in the shooting death of 19-year-old Samantha Teeter. I'm joined right now by criminal defense attorney Carlos Tanner. Mr. Tanner, we're watching this video. We're seeing this testimony. The idea that Whaley proceeded to insert 2 kitchen knives into his front door jamb, and as you saw, he detailed this to the jury on the door itself. And then he sat on one of his couches with his revolver. What does that tell you?
Well, I think those are the kind of details you and I were discussing earlier. Those kind of details, that kind of strange, unusual behavior is just the sort of thing that might suggest to a jury that there was some sort of fear. Whether the fear was reasonable or not is still a big question. But it's highly unusual behavior, and I think, again, the defense is in part because of this notion of whether they'll have to put their client on the stand, but that's a common tactic, if you will, that skilled defense attorneys will do. They'll try to put in evidence of self-defense or evidence of a mental state suggesting someone is fearful for their lives or fearful for their safety through other witnesses so that they can still get the jury instruction, still have the jury consider self-defense, but yet at the same time reserve the right or have the option not to call their client but still get the instruction. And it's even better when you can do that through the prosecution's witnesses.
So I imagine the defense, when they start their case today, they could try to show that, look, this just shows how serious of a threat this was for him. Look at his nature of what he thought the threat was. It's not a paranoid threat. It's not it comes out of nowhere. He legitimately had a legitimate fear, and he wouldn't have taken these actions to do otherwise. Is that the way that they would kind of flavor that?
Yeah, I think you're right. I think that's exactly what they'll try to do.
And then let me ask you this: the idea that Miss Teeter, they had knocked on the door, that Whaley had tried to call them earlier in the night, no one was picking up. I mean, that the fact that he knew that they were coming back, but that he tried to call them and he couldn't get a hold of them, that they knocked on the door. I mean, is there any way that the defense can frame that in the sense that, look, he tried to be the good guy here. You know, he tried to call and find out where they were. They weren't picking up. They knocked on the door. I mean, he didn't know who it was. How do you flavor that as a defense attorney?
Well, I think that's how I would do it. I would try to say, look, he called, he made attempts to get in touch with the only people who, at that point, had the right to come to the home and couldn't find him. And that probably added to his nervousness about, the threat that was imposed on him and whether, at that point, it set the tone for when he gets the knock on the door, when he hears somebody trying to come into the home. He probably, based on his inability to get in touch with those 2 people, believed that it was somebody other than them. But now, of course, that's one of those gray area facts, because the prosecution can take that same argument and say, well, look, at the very least, he knew there was at least 2 people who might be coming to the home, who might have a right to be at the door, and frankly, one of whom he had given a key to. So that made it all the more dangerous that he actually shot through the door without knowing who it was.
Yeah, you make a great point. It's from just a common sense perspective. If you give someone your keys, or you give 2 people your keys, or someone's coming up there, you can expect they're going to come back at some point. How surprised are you that it would be Corey Mays as opposed to Miss Teeter, who he knew was coming back that night? That's a difficult part, I think, for them to get over. I do have a different question for you in the terms of Mr. Whaley had purchased a gun for about $500. We know that in Iowa, the law kind of changed, that a sheriff's right to issue non-professional permits to carry changed from may issue to shall issue. And we saw this increase in non-professional permits being issued to people. It's easier for people to get guns. And there was also a change in the law in the sense that it's no longer you have a duty to retreat in Iowa. Now there's more of a stand your ground kind of a law in Iowa. What do you think about that change in the law in terms of the facts of this case?
Well, they've normalized it basically to my area of the country. Being from Mississippi, I mean, gun laws are very lax, and that's I mean, it just seems like they made it easier to get firearm permits and such. However, you still have to go through the process, right? So, in this case, there's a question of whether he had the gun lawfully, and you know, then you bleed over into what's come up frequently, as you know, in a lot of these trials over the last couple of years, where in most places the castle doctrine has been expanded, and the stand your ground laws have been used over and over and over again in these in the more recent trials.
See, but I think from a prosecution standpoint, and maybe that's why this case is so important, is that if you if you said if you make the laws a little more lax and it's easier for people to get guns and you give people more of a right to use lethal force, I think it's even more important to bring these cases to trial and say, it's not so simple, everybody. It's not so simple you could just use deadly force whenever you think it's right. And I think it becomes an even increase to really make sure that people are restricted in a certain way and these cases are brought to trial and that not everybody is given a free pass. Would you agree with that?
I agree with that, but of course, you know, most of these trials, whether these cases go to trial, is usually a matter set by the defense, and so while these new areas of law, these new statutes being put on the books are really important and need to be tested through litigation. You know, as a criminal defense lawyer, you never want to, at the expense of your client, go out trying to make new law, so to speak. On you know, when there's too much of a risk involved. But there are a lot of cases like this one, cases, as we say, cases that just have to be tried, where these issues are going to be at the forefront, up front and center, and the limits of the law are going to have to be tested so that we as members of the public have a better idea, and as legal practitioners have a better idea of what's permissible and what's not in light of these new regulations.
Exactly. You said it so right. It really is like that. Stand by, Mr. Tanner. We're going to play another clip from this investigator, Terrence Prohaska. Again, we're covering the Larry Whaley case out of Iowa. 61-year-old man been charged with second-degree murder in the shooting death of 19-year-old Samantha Teeter. As we've been talking about, he shot her through the door of his apartment when she tried to enter with his keys, but he claims self-defense. He claims that he had a reasonable expectation that someone coming into that apartment was not Teeter, that it was possibly two other individuals, and specifically Corey Mays, who was his former roommate, who was claimed to be very dangerous. And it's going to be interesting today when live testimony begins around maybe 10 a.m., maybe even a little bit later, about what the defense is going to do. And it's going to be really interesting to watch. So right now, I do want to play for you a little bit of more clips from yesterday, in case anybody missed it. This is the final part of the investigator Terrence Prohaska's testimony. We're talking about right now is when the shooting takes place, and these are some crucial details that we're going to analyze in a little bit. In the meantime, here's this clip.
The interview, investigator Prohaska, you were talking about the defendant got home from Walmart, and you told us about the conversation with Deb Ewing and what happened there. Did the defendant then say after he got home when he put the knives in the door jam?
Yeah, immediately after he got home, he described putting the knives in the door jam.
Did the defendant say what he did after that?
Yeah, he said there's a long couch along the east wall. He said he sat with Deb down on the couch with his gun.
So the defendant told you he was sitting on the couch and he had his gun with him?
Yes, sir.
While he was sitting on the couch, did the defendant tell you if he heard or saw anything?
Yes.
What did the defendant tell you?
He said he saw the doorknob starting to move, He said when he saw the doorknob started to move, he leaned over and told Deb what he was seeing, and then he said he heard knocking at the door.
So the defendant told you heard knocking at the door.
Yes, sir.
Let me back up. May I approach?
Yes.
I'm going to hold up State's Exhibit 65. Investigator Prohaska, are you able to see that okay?
Yes, sir.
You see where there's a number 2 and there's a couch?
Yes, sir.
That represents there was a couch in the defendant's apartment. Do you see that?
Yes, sir.
Had you been into the defendant's apartment after this interview?
Yes, sir.
And was the couch still there?
Yes, sir.
And from the sitting on the couch, could you see the door?
No.
Why not?
I physically sat in the door exactly where Larry described, and, or excuse me, on the couch.
A laser pointer.
Yes.
Push down on the red button here.
Okay, got it.
Okay, we'll go back to State's Exhibit 65.
I sat there. I knew the couch hadn't been moved because in the carpet you could see the impressions where the legs were still. Yeah, many of you know if you've ever vacuumed, it's hard to get those out. So they were there. So I was sure that the couch was in the same spot. So I sat in Larry's position, and there was no way I could see the doorknob at all without getting up.
Investigator Prohaska, going back just for a second to, you talked about the knives the defendant described. Is this what the defendant's describing to you?
Yes, sir.
Because when you were at the apartment, the knives were no longer in the door.
No.
So you're just telling us what the defendant told you during this interview.
Yes, sir.
And the defendant told you, he said he saw the knob moving from the couch is what he told you.
Yes, sir.
Is that when he said he heard knocking at the door?
Yes, sir.
So after the defendant heard knocking at the door, what did he say he did?
He said he got up and walked over to the door and shot through it.
Did the defendant say if he saw anything going on to the door before he fired a shot?
Yes, he did.
What did he say?
He said he now saw the top lock being manipulated.
So the defendant got up, walked over. Did he say how close to the door he got?
We were in an interview room, which is about 10 by 10, and he stood at I asked him, I put a chair up to pretend it was the door, and so I would say he stood where he thought he was, and it was about 5 feet or so.
So the defendant showed you he was about approximately 5 feet away, and he said he saw the top lock being manipulated?
Yes.
Did the defendant say what he did next?
Yes, he said he yelled to get back from the door and fired 2 more rounds to the right of the door.
And I need to back up, and that's my fault. Earlier you talked about a shot being fired.
Yes.
So I just want to make sure the sequence is right. So the defendant's on the couch, and he says he sees the doorknob moving.
Yes.
Then he said he got up,
Yes.
or he heard knocking,
Yes.
and then he gets up.
Correct.
Did the defendant say whether the first shot happened before he saw the top lock being manipulated or after the?
The first shot was, I believe it was he saw he fired the first shot before he saw the top lock being manipulated, is what I believe he said.
And where did he say he fired the first shot?
through the door is what he said in his own words.
Did you ask the defendant why he fired the first shot through the door?
Yes, he said it was a warning shot.
So after the defendant said he fired the first shot, what did he see or hear next?
He said he yelled to get back from the door, and he saw the top lock being manipulated, and he said he thought the door started to open just briefly a little bit, and he fired 2 more rounds to the right side of the door. He, during the interview, he described them as pow pow.
Was there a delay? Did the defendant describe a delay between the first shot and the second and third shot?
Yes.
And he said the second and third shot were farther to the right?
Yes.
Did you ask the defendant why he fired those 2 shots?
Yes, he said they were warning shots again.
Did you ask the defendant if the door ever opened?
Yes.
What did he say?
He said it never opened.
Did he say if the knife stayed in or had fallen out?
No, he described the knife stayed in the entire time.
Did you ask the defendant who was on the other side of the door?
Yes.
What did he say?
He said he didn't know. Then he said he thought it was Corey.
Welcome back to the Law&Crime Network, everybody. This is Jesse Weber. We're covering the Larry Whaley case out of Iowa. You're watching the testimony of police investigator Prohaska, and this is really important because he's detailing what was told to him by Larry Whaley in his police interview about what happened that night of the shooting. And remember, he is charged, 61-year-old Larry Whaley is charged with second-degree murder in the shooting death of 19-year-old Samantha Teeter. I'm joined right now by criminal defense attorney Carlos Tanner. Now, we just heard, Mr. Tanner, that there was the shots. We know that 3 shots were fired. He only yelled for someone to get away from the door after he first fired through it. There was 1 shot through and we know the pictures that were shown to the jury revealed that 1 shot was fired from inside the apartment through his front door, and then 2 were to the right of the door, showing them some sort of movement. What does that tell you about the number of shots and his reaction to what he said, or yelling for help right after the shots, or he didn't even wait? What does that tell you?
Well, it tells me a couple of things. On the one hand, it tells me that the accident argument is going to be a bit more of a tough sell than had there just been 1 shot, for example, right? Mm-hmm. Because if it was an accident, maybe he could argue, particularly if he took the stand and was going to tell the jury exactly what was going through his mind at the time, that he just intended to point the gun at the door, but maybe out of fear he squeezed the trigger, or maybe when he was raising the gun he squeezed the trigger. But it's going to be a little bit difficult, well, a lot difficult, frankly, to explain away 3 accidental gunshots. That's going to be a tough sell for anybody to believe.
You know what's weird about this case is that Whaley had told Teeter, the victim in this case, and her boyfriend that he had a gun, and they even went to buy shells with him earlier that day. They had an interesting relationship, that they knew what was going on, that he obviously felt some sort of threat.
Yeah, and on that one, I think when you put it on the scale, that leans more towards the defense, in the sense that they could argue that he was fearful, that the fear he had was reasonable, and more important, that it was imminent, that he felt that it was necessary immediately to get the gun. But then again, on the prosecutor's side of the scale, you could say that it was a plan, maybe, which would have gone more towards their initial charge from the first-degree murder charge that was initially lodged against the defendant. But it still doesn't answer the question for how he would have known who it was behind the door when he did.
They dropped that charge from first to second degree without giving an explanation, but what you've explained it before a little bit earlier today, but for our viewers, why do you think they did that?
Well, I think it would have been really difficult to prove, particularly because there are only two people in the room at the time. And the defendant and Miss Ewing. And if Miss Ewing, the defendant certainly didn't say or suggested that he did not know who was behind on the other side of the door, and on the other side of the door, it would have been extremely difficult for the prosecution to demonstrate or to get a jury to believe that it was a specific person that he was aiming to kill, which would have been required for murder one or first-degree murder.
Right. No, I agree. I think they instituted the right charge here. It sounds very like second-degree murder from our law school. Weird things about this case, so the more interesting aspects of it, is the communication between Mr. Whaley and the court, specifically the letters that he wrote to Judge Foy, which you don't really see every day in every case. A defendant claiming everything from he wouldn't receive a fair trial, that evidence is being withheld, that his attorneys are lying to him, that there's been witness tampering, that his cell phone and car have been stolen, his rights have been violated. When you look at those letters, what did you think of it when you first saw these letters?
Well, I thought the letters were they were disturbing, but on the one hand, and also they let you in a little bit to the defendant's character. That it raises the question of whether he's got all his faculties about him, but then at the same time, you could look at it differently and wonder, just how maybe the defendant's sharper or more sharp than we want to believe, right? Because at some points he even suggested that he had at least analyzed for himself and had broken down the law for himself to make the argument to the judge that even if self-defense doesn't apply, this shouldn't be murder one. A lot of clients aren't going to come up with that argument. So for him to do that suggests he's either crazy or crazy like a fox, if you follow me.
Do you think any of these letters will be introduced at trial at any point, or are the jury's not going to see them?
Yeah, no, I don't think the jury's going to see them. I think the time to get those in could have been, although it was a bit of a far shot, would have been during the prosecution's case. But that's another problem that you have whenever the defense is trying to decide whether Mr. Whaley should take the stand. Because if he comes in and starts testifying about self-defense or about what his mental state was, maybe those letters can be used to either impeach him or to attack his credibility.
That's interesting. And in terms of if he is found guilty and grounds for appeal, do those letters have any effect?
I don't know what effect they'll have. They'll certainly be a part of the record and made exhibits at the appellate phase of the case if it comes to that. But I don't know how much probative weight they have in terms of warranting an affirmance or a reversal for that matter.
Right. All right. Well, we're talking about the Larry Whaley
case. I
think
inevitably he's going to attack his own lawyers if he gets convicted, and he'll try to use those in some sort of appeal, direct appeal, or a habeas corpus petition, arguing that his lawyers didn't do their job. But from what I've seen, they've done a really good job with what they have to work with.
Yeah, shocker that he would lose and blame his lawyers. But as we know, that's not an easy thing to claim, the ineffective assistance of counsel, because that's a really high burden, right? Right. All right, so we are showing you the clips from Larry Whaley, what you might have missed in testimony from the past few days. We are awaiting live coverage. As soon as we do have that live feed in the courtroom, we're going to go directly to it, and again, the defense will begin their case. I want to play for you right now the testimony of Victor Murillo, the crime lab analyst in this case, really dissecting some of the evidence in this case as we build up into it. Remember, the prosecution has closed their case, the defense will begin theirs, so we are recapping what you may have missed. And even for those of you who have watched it, it's good to recap for anybody who's following this case. Here is the testimony right now of Victor Murillo.